Actually, that's a good idea. We don't move up. Now it dawned on me why we don't move, because you don't want us to share that. I didn't even think of that. That's very good.
Oh, is that how it works now? Different forum. Oh, okay. So I was watching some videos. Some people had more fast cars, some people won. Okay. I should have rehearsed with my hands.
I have a final question. Back in March and April, did they do live arguments, or did they go video back in March and April? You know, when you start the whole bad thing. It was video. So he just started September live, or later, earlier? May have been live. May. Okay, but they did video, and then that's good. Right. Thank you.
Judges of the court. Hear ye, hear ye, hear ye. All persons having any business before this Court of Appeals held in and for the state of New York may now draw near, give their attendance, and they will be heard. Please be seated.
Okay, good afternoon, everyone. The first appeal on this afternoon's calendar is Appeal Number 77, Chen versus Insurance Company of the State of Pennsylvania. Counsel?
Kenneth Gorman for the plaintiff appellant. I'd like to reserve 2 minutes for rebuttal.
You may, sir.
Thank you.
You're welcome.
Do I begin?
Please proceed, sir. Yes,
Okay.
please.
The procedural problems of this case simply cannot be overlooked. I mean, with regard to the issue of waiver, there's no dispute that the plaintiff has always sought statutory interest, which included prejudgment interest that was already factored into the judgment and all post-judgment interest. This was made clear in plaintiff's initial demand letter that was sent on October 31st, 2013. It was made clear in plaintiff's complaint. It was made clear in plaintiff's amended complaint, and it was made clear in a motion for summary judgment. ISOP waived this issue by failing to address it when it opposed plaintiff's motion for summary judgment. This is the only reported decision in the state of New York, and I can't find any decisions outside of the state of New York which applies the concept of a contractual waiver in a litigation context when opposing motions made on notice. And this decision has the potential of overturning or at least significantly transforming the decisional law regarding the legal doctrine of waiver. With regard to re-argument, granting ISOP leave to re-argue issues that were not previously raised prior to the entry of the final order is contrary to the plain meaning of CPLR 2221D and the decisional law from every appellate court in the state of New York. This court held in Simpson versus Lohman and Riley versus Steinhardt that a motion for re-argument cannot be used as a vehicle to advance new legal theories that were not previously asserted.
But aren't we really dealing with here with the court's perception that there was a mistake in law?
I'm sorry, could you repeat that, please?
Sure. These masks make it hard sometimes for all of us. Aren't we really dealing here with the CPLR question of whether there's a mistake in law on the court's part? And a court always has the right to go back and address a mistake in its legal analysis.
That's right, but I mean, there was no mistake in law here. I mean, ISOP didn't even mention the word interest in any of the papers that were submitted in opposition to our motion for summary
But it
judgment.
argued it did drop down, sorry. It argued, right? It did
ISOP
drop down.
argued that it dropped down with regard to the $1 million limit. I mean, I'd just like to refer the court to ISOP's, when ISOP proposed our motion for summary judgment, it acknowledged at page 389 of the record that the judgment was $2.3 million and that it had nearly $400,000 of prejudgment interest factored into it. And at page 333 of the record...
But weren't they, isn't that what the focus of the arguments was? It was the drop-down issue, and it seems to me like they never really, nobody ever really got to talking about interest in particular. The focus was on, did they have to pay the whole amount or didn't they? And then once the court said, no, they didn't, then the allocation of who was responsible for what interest really came to light. Isn't that what happened? I mean, I know that your references to the record are accurate and all of that, but it doesn't demonstrate really what the nature of the discussion was, and I think the context of it has to be taken into account, doesn't it?
No, I mean, when ISOP opposed our motion for summary judgment, it said, and I'm going to quote what it said, if ISOP is liable at all, it is liable only for the amount of the judgment, which it acknowledged included prejudgment interest, less the $1 million limit. Not less the $1 million limit and the supplementary payments, just the $1 million limit. This The issue of interest is governed by the contractual language, and
So
there was no reason
let
why...
me ask a question on that, on the interest question, your response to Judge Stein. Is your argument that the follow the form requirement means that post-judgment interest goes back to the primary policy? The excess policy, of course, will cover that. So the post-judgment interest would be on the full 2.3.
That's correct.
All right. And that's based on a follow the form argument, is that right?
That's correct.
All right. Just so I have it clear. Thank you.
Okay. If ISOP felt that it had no obligation to pay interest on the judgment, it had to raise the issue when the plaintiff moved for summary judgment, which clearly...
Well, I don't understand that to have been their position. I understand their position to be that they were required to pay only pre-judgment interest on the portion of the judgment that, or am I getting it backwards? Post-judgment interest? No, well, only pre-judgment interest on the portion of the judgment for which they were liable.
Are you referring to the supplementary payments provision in the ARCH policy?
Yes, yes, I am referring to that.
Okay.
That based on that policy, on that provision, that the excess insurer was saying that's all the interest we're responsible for.
ISOP raised that argument after the final order was entered. Before the final order was
I
entered...
understand that. That
Right.
goes to your waiver argument.
Right, that goes to the waiver argument.
I was sort of following up on Judge...
Oh, just with
Sagan's
regard to the language
question.
of the supplementary payments provision regarding prejudgment, that's what it says.
Right.
But doesn't the colloquy at oral argument suggest the same, that that was their understanding, or that was their position? Let me put
I'm
it a
sorry,
different way.
at oral argument?
Yes, the colloquy at oral argument.
Yes.
Doesn't that help us to understand what they are saying is their position with this drop-down argument?
That was raised for the first time at oral argument. It wasn't raised in the papers at any time before that. I mean, the case law is clear that you can't raise issues for the first time at oral argument.
I understand, that was not what I said. My point was, didn't the oral argument help to clarify what their position was? Their position one being that it is not waiving their argument because it would have encompassed this position that they are not liable, or they're not responsible, let me put it that way,
It was a
for
one-sent-
the interest that ARC would have been responsible for.
When the
ARC.
court discussed interest, ISOP made a one-sentence comment on the 1.3. On the 1.3 does not reflect the substantive issues that ISOP briefed after the final order was entered. It just said on the 1.3.
Doesn't that mean I'm not liable for the interest on the one?
That's correct, raised for the first time
Okay,
at
and
oral
isn't that
argument.
close to the argument on it doesn't drop down?
Drop down with regard to 1 million. I don't think I don't think interest has anything to do with the drop-down provisions. The drop-down provision only has to do with ARCH's liability limit, which was clearly set forth in the declarations of its policy and in the declarations of ISOP's excess policy.
Chief, if I may?
Yes.
Yeah. So I just want to be clear about one thing. Are your post-judgment arguments and your pre-judgment arguments regarding to interest, do they rise and fall together, or are you making, can we look at them separately, and do you have separate arguments as to them?
Well, the pre-judgment, with regard to the pre-judgment, I'm sorry, you're talking about after the order was entered, you're talking about just with regard to the issue of post-judgment interest and pre-judgment interest?
I'm talking about pre and post. Is it all one analysis? You get them all, or you get none, or part? Or is there a separate analysis for the pre and the post?
It can be a separate analysis. I mean, I can't, because the ultimate net loss provision in ISOP's policy cannot be reconciled with the supplementary payments provision regarding pre-judgment interest. ISOP is responsible for all pre-judgment interest. That's our position. And that's, I don't know if it's, I don't think it rises and falls together. I think post-judgment interest and pre-judgment interest are separate in this case. I think that if ISOP raised the issue at the appropriate juncture, maybe the argument would be different, but it didn't. And at page 333 of the record, it conceded that it had to pay the judgment less $1 million, not less $1 million and the supplementary payments provisions, which include prejudgment interest. It didn't argue that, so it waived it. But if it argued it at the appropriate point, I guess it could make that argument, but I would say that it still wouldn't pass muster because it can't be reconciled with the ultimate net loss provision in its policy, which doesn't make any provision for prejudgment or post-judgment interest.
Thank you, counsel.
Thank you.
Counsel?
Thank you, Your Honor. Elizabeth Alstrand for the respondents. Just to respond briefly about the reference at page 333, I think it's clear when you read our opposition to the motion for summary judgment in total, there is many statements that make our position very clear. At page 331, for example, we say, to the extent plaintiff seeks reimbursement of the entire judgment, his motion should be denied for the additional reason that the maintenance provision precludes ISOP from dropping down and satisfying that portion of the judgment that would have been covered by the Arch policy had it not been rescinded. It was our position throughout summary judgment and even before in our answer. The maintenance provision does not permit a drop down in these circumstances.
Counsel, I'd like to just move on a little bit to the substance of this, and
Sure.
particularly with respect to post-judgment interest. And as I read that provision in the Arch policy, it says, all interest on the full amount of any judgment that accrues after entry of the judgment and before we have paid, offered to pay, etc., the part of the judgment that is within the applicable limits of insurance. So as I read that provision, it seems to say to me, Arch will pay, and they'll pay all post-judgment interest, let's say on $2.3 million here, up to the point where Arch says, here's the $1 million we owe, right? And then they're done with interest payments. And that seems post-judgment. That seems reasonable to me, because why would they be on the hook for a secondary carrier's award after they've offered their payment? But Arch is gone here. So there's no way to stop, there's no one paying. So the secondary carrier can not pay on the judgment for years. That's being put on the Arch tab, but no one's going to pay that. So the way I read that provision, and this isn't a drop-down issue, but the way I think that provision could be read is Arch owes nothing here, right? Arch is out. So at the time of the judgment, Arch has paid everything they're liable for in the insurance, zero. And the clock starts to run on the secondary carrier for post-judgment interest. And wouldn't, as a policy matter, that make more sense? Because the way the thing is designed is if Arch was there, Arch could end that obligation, pay 4 days of interest and offer the $1 million, let's say. But now Arch can't do that because they're not a party anymore. So it seems like the effect of that provision should still hold because, you know, you're not dropping down, but, and why wouldn't you read that provision that way?
Your Honor, if you read it in isolation, that's a plausible reading. However, when you read it in the context of the ISOP policy, specifically the maintenance provision, which requires the maintenance of the $1 million limits, but also says that if you fail to comply with this requirement, we will only be liable to the same extent that we would have been had you fully complied.
And I'm saying you would be, because you're only liable for interest after the time Arch pays whatever it owes on any judgment. They owe nothing. So it's on your tab now.
Well,
and that's how this provision works. Even if Arch was there, let's say Arch went in, day the judgment came out and said, we're offering you, here's our $1 million judgment that we owe you.
I agree.
And you say, no, I'm not paying it. I want to do whatever.
Your Honor, I agree with you if Arch had stepped in and paid. It would be a different situation if the policy was still in effect. But the maintenance provision says our obligations are only going to be the same as if they were in effect. And if they were in effect, Arch would have paid the $1 million. Then you look to the next piece, which is you're saying that, well, Arch and our insured who is the one who resulted in the policy being voided for their material misrepresentations, that responsibility should shift to ISOP. But the insolvency provision makes very clear that your inability to pay, your primary's inability to pay, is not going to require us to drop down and pay anything in the insurance area.
But it's not a drop-down issue. I mean,
I agree with the judge. I think that his reading of it is closer to what I seem to see here. I'm wondering, it's not a drop-down. I wouldn't characterize it that way. it's straightforward interest provision that has strong public policy purpose to it. The public policy purpose is that the primary pays up so the excess can know what they have to pay and what it owes. But if the primary can't, then the excess is in essence stuck, not with what the primary owed on the principal, but it's still stuck with those interest provisions because of the follow the form section of the policy. It doesn't escape them because of that. Otherwise, it would have an infinity to pay. So
Well,
as
Your
a
Honor,
public policy matter, that makes sense, particularly with the language. The language, it seems to have been designed that way.
Well, 2 points in that regard. For one, our coverage grant says that we sit on top of the ARCH policy, and there are 2 coverages the ARCH policy provides. It provides $1 million limits for bodily interest, and outside of those limits, it provides interest. So we sit on top of both of those. We can't be forced to drop down into either. The other point is that the public policy is really tied to the fact that the primary is going to be the entity that controls the defense, and they are going to be in control of the situation. And that control shifted back to our insured when that policy was voided. We didn't even get notice of the fact that ARCH had withdrawn its defense until after judgment had entered. That control never shifted over to ISOP. So the public policy piece really does not translate.
I'm not sure I understand, because I thought that there was, I thought that the primary carrier was out because of a material misrepresentation by the underlying insured.
Yes, and they brought a DJ that was affirmed on appeal, and
Right,
then they
and you,
withdrew
so
their counsel.
you were familiar with all this. You knew all this was going on. There was no surprise to anybody.
ISOP was aware from a separate litigation that ARCH had filed a DJ. Neither ARCH nor our insured ever told ISOP that they had succeeded in that DJ or that they were withdrawing the defense. They were never put on notice of that.
I'm over here. Can I just clarify, because I think I may not understand what you claim you are liable for. I thought you were arguing that at the point in time when there is a judgment, right, that's when your interest clock starts ticking for everything that's above the underlying insurer, the primary insurance policy. Am I misunderstanding you?
Our argument is that our liability is exactly the same as it would have been had the ARCH policy been intact, because that is consistent with the language of the maintenance provision. And that is, we would be liable for the $1.33 million, pre-judgment interest on that amount, which is 100% consistent with the first clause of the supplementary provisions, and no prejudgment interest because the $1 million was never paid. ARCH obviously wasn't going to pay it because their policy was voided. But what normally happens in this circumstances is the insured steps in and they pay the money. And Cam Chung's inability to do that in this circumstance does not change the result. That's what the insolvency provision clearly directs.
What I'm trying to figure out is the calculation of this interest. Does that not begin in terms of your liability at the point of the judgment?
In this case?
Sure, this is the case in front of us. I'll go with that.
Okay.
This is the policy we're trying to
So the way that, to move things forward, because this case basically stagnated after the May 2nd order on the summary judgment. Plaintiff submitted his proposed judgment, and our view of it was that it was an order that said we didn't have to drop down and therefore not responsible for anything within the primary area. He filed his proposed judgment, which was totally inconsistent with our reading of the order. We filed a motion to resettle, we filed another motion, we're here today. We, in connection with our second motion, also submitted a proposed judgment, and that judgment is what the court signed. And it provided that we would pay the $1.33 million, pre-judgment interest on that as calculated within the underlying case, and then post-judgment interest from the time that summary judgment entered in this case, and our liability for anything attached. Because there's a difference between what our insured is liable for and what ISOP covers, right? This is an action to collect on the policy because our insured didn't satisfy the judgment. But in order to get a collection from ISOP, plaintiff has to establish that it's covered under the policy. Not just that from a global sense, they're entitled to that money from Cam Chung, our insured.
Let me just follow up on Judge Garcia's question in a little bit different way. He read you from the Arch policy, 1, subparagraph G, but the preface there, right in paragraph 1, setting out Arch's obligation, says that it will pay, and that would then pick up the post-judgment interest, in any suit against an insured which we defend. But they didn't actually defend this suit. So why do they have an obligation? Why doesn't that obligation entirely fall on you?
Well, Your Honor, that language has been, that wasn't really a focus in this case. Everybody assumed that Arch had this obligation, and it's never been disputed. And that's because in other cases that have looked at similar issues or have looked at that issue, it's presumed that that means that they would have an obligation to defend, that a defense would otherwise be required. So that the policy language doesn't change, for example, if the policy is voided or if they're insolvent. It's just more globally, would a defense be required under that policy? Because if not, then if a primary carrier wanted to avoid its interest obligations by wrongly defending, I mean, you would have a situation where, oh, you didn't provide a defense, now perhaps you don't have to pay the interest. And so that piece of the provision has not been interpreted to actually require the defense, but rather whether a defense would be owed under the policy language.
If I understood your earlier answer, if you had stepped in and assumed the defense, you would then not dispute that you would be liable for the post-judgment interest. If I misunderstood, let me know.
Well, this is an indemnity policy, so we didn't have a duty to defend. So had we...
I understand, but you were making a big point of the fact that you had no notice and you didn't actually have the opportunity to control the litigation in response to Judge Fahey's question about public policy. And so I'm wondering what you thought the import of your answer was.
Well, that was just circling back to the general sort of espoused public policy that's been articulated about the supplementary payments in general, because that provision has been interpreted a lot because it does put a big onus on the primary insurer. So it's been interpreted a lot to confirm that, yes, the primary carrier owes all the interest on the whole judgment, not just its proportionate share. But in terms of whether we would owe it at that point, I guess it would depend on the circumstances, because there's just a lot of variables there in the sense that the plaintiff was defaulted, and that's why the judgment entered in the way that they did, because they didn't have counsel, they didn't appear. So if we had appeared, who knows where the case would have even gone. So I'm not sure I can...
So your position is that you are responsible for post-judgment interest after a judgment was entered against you?
Yes, or if Camp Chung had stepped in and paid the $1 million, then absolutely, because the policy language clearly would have cut off the primary layer's obligation. Our overarching mantra in this case has been, we are only liable to the same extent that we would have been had the primary policy stayed in place. And that's the purpose of the maintenance provision and the insolvency provision. I can see my time is up.
Thank you, counsel. Mr. Gorman?
Just with regard to the maintenance provision, ISOP's maintenance provision required the insured to maintain a primary policy with a limit of $1 million in coverage. There is nothing on the face of ISOP's excess policy that states that the insured was required to maintain the primary limits plus the coverage.
Well, but what about the definition of ultimate net loss and the general coverage provision, which incorporates ultimate net loss, which refers not to the limits of the underlying insurance, but to the underlying insurance, which when I look at the schedule of that in the excess policy, there are two columns. One is, this is the underlying insurance, and this is the limits of the underlying insurance. So they use those terms not interchangeably, it seems to me. They're two different things. So why?
The ultimate net loss provision in the excess policy, ISOP's policy stated that it was responsible for the ultimate net loss in excess of the Arch policy limits.
No, that's not how I read it. It says ultimate net loss is accepting, however, the underlying insurance, Whereas if you look at the maintenance provision, it refers to the limits of insurance.
The limits...
To me, those are two different things. The limits is the 1 million. The underlying insurance is the 1 million plus the supplemental, or whatever else is in the policy that we're not talking about right now.
Well, I'd like to refer you to the Second Circuit's decision in Home Insurance Company versus American Home Products Corporation, which we cited in our brief. And in that case, the excess insurer who followed form to the primary policy was not responsible for paying post-judgment interest on the award because the excess policy explicitly excluded interest accruing after entry of the judgment from the ultimate net loss. If ISOP did not want to...
Okay, but that doesn't mean that that's the only way to exclude it. Here, they excluded it by their definition of ultimate net loss, which was referring to the entire policy, which includes the supplementary coverage.
I did not see the ultimate... I did not interpret the ultimate net loss to encompass...
Well, that's clear from your briefing, that see, I guess that's what I'm asking you. Aren't you conflating two different terms? One term is the limits of the underlying policy, and the other is the underlying policy more generally.
Well, this was a follow the form policy.
I understand that.
And, I just want to refer you to Raggins, which we did not discuss. But in Raggins, the excess policy stated that HIC will pay all sums which are in excess of the primary policy limit that the insured shall become legally obligated to pay as damages. In this case...
Well, that's exactly the language that I'm suggesting may be missing here. It doesn't refer to the limits in this particular policy. It refers to
At
the
page 3,
underlying insurance.
I want to refer you to page 398 of the record. In this case, it has the same language. ISOP followed form to the ARCH policy, and that policy states, it has the same language as the language in Raggins, that it will pay those sums that the insured becomes legally obligated to pay as damages. There's no distinction. And like the policy in Raggins, ISOP's excess policy did not mention interest as a covered sum of damages, and ISOP's policy did not limit the definition of sums to any particular category of damages or exclude interest.
Counsel? I'm sorry, Chief, may I?
Yes.
Counsel, what post-judgment interest has the defendant agreed to pay, and what are they contesting? Post-judgment interest?
The post-judgment interest that they paid was after, they paid post-judgment interest on a portion of the judgment.
Which portion?
They paid a post-judgment interest on, I believe, $1.5 million. They're responsible, it was our position that they were responsible for paying post-judgment interest on the entire judgment.
But I thought they only paid us a certain, let's say it's the 1.33, but let's say I thought they only paid a portion of time post-judgment interest even on the, let's call it the excess award.
They did.
And what was that period that they paid, and what didn't they pay?
They paid from May 2016 to June 2017 on, I believe, approximately $1.5 million, which brings it up to about 1.7 million.
And what does that period represent?
I'm not sure. I don't know. I don't have an answer to that question. I was never able to figure it out. I don't know why they paid it.
Thank you, counsel. The next appeal on this afternoon's calendar is appeal number 78. We'll wait a moment.
Thank you.
This is appeal number 78, De Lorenzo versus Windermere owners. Counsel?
Yes, I'm sorry. Good afternoon, Your Honor, the court. Mark Bogatin for the plaintiff. For the appellant, I would ask to reserve 2 minutes on rebuttal, please.
You may, sir.
Thank you. The appellate division, in the opinion below, held that a defendant landlord in a rent overcharge case, whether the landlord has obtained a destabilization of an apartment based on a payment of individual apartment improvements, IAI, The appellate division held that the landlord has no obligation under the law to comply with what's referred to as the useful life rule. It's plaintiff's position. We submit that that was wrong. That holding was wrong.
Counselor, are we no longer talking about whether they established that they made repairs in excess of the threshold? Now, we're just talking about whether their deregulation violated the useful life rule.
That's correct, Your Honor. Yes, that is correct. Given the procedural posture of the case, where we are now,
Okay.
obviously it's our position they didn't make enough. But no, that's behind it. That's been litigated. Appellate division ruled that they met that part of the burden, that they did prove that they spent X. Okay.
And so then are we looking at the proof insofar as it related or negated any relation to the earlier repair?
Yes, Your Honor, 100%, 100%.
Okay. And the trial court came to one conclusion, right? And the appellate division came to another, right?
On a question of law, we believe, yes, Your Honor.
Well,
not on a factual
also
matter, on a legal matter.
On the facts of whether they violated, they were duplicative of, or they proved that they were not duplicative.
No, we don't agree with that position. We believe the appellate division ruling is very clear. Appellate division ruled as a matter of law that the landlord has no obligation to comply with any useful life schedule. It's right in their opinion.
Let's assume we don't agree with you on that. I think that there could be a reading of it to say that what they said was that they didn't have to comply with the schedule that applies to the more general types of improvements. But if we don't agree with you on that, then am I correct that it's a factual difference and that we have to determine which set of facts more comports with what the record is?
Well, if you're looking at, if one is looking at the facts, we believe that there's a total absence and failure of proof on the part of the landlord. The landlord's witness, the property manager, Balkman, was asked repeatedly, or at least 2 or 3 times, tell us about the prior improvements. He said, I have no idea, no recollection.
I think before you get to that, Judge Stein was trying to ask about the appropriate standard of our review. That is, the trial court made one set of findings, appellate division made an opposite set of findings. Is our standard review to decide which of those is more supported by the record? Or is it a different standard?
I would say, in part, yes, but I don't believe that well, first of all, I don't believe there is any evidence whatsoever introduced by the landlord as to compliance with useful life. On appeal, they're saying that useful life was satisfied or made irrelevant because the prior improvements were washed away. That's their language from their brief. Washed away by a flood. If you look at the evidence in the trial record, there's no testimony by the landlord's witness or anybody else's witness that there was any flood damage to this apartment.
So are we?
I'm sorry?
I'm here, that's okay.
Yes.
So are we then into the legal question of who has the burden of proof?
Of course, I mean, yes, 100%, Your Honor, I certainly agree with that.
But it seems that we can't avoid a factual analysis in deciding this, right?
Well, I would put it a little bit differently, but
Go
I
ahead.
would put it whether or not there's any proof. I think there's an absence and failure of proof. That's our view.
Mm-hmm. And what about the useful life argument that the proof here, that the useful life rule only applies to equipment and furnishings and not to improvements, and that the bulk of these, bulk of this work was characterized as improvement?
Yes, Your Honor. We believe that's the distinction, their distinction without a difference. First of all...
I'm sorry, it's a distinction without a difference?
We would characterize that argument, which is their argument, a distinction without a difference.
Well, you know, the problem here is that I'm subjected to a great deal of HGTV. My wife watches it religiously. And as a result of that, from having to stand around and watch HGTV, I've come to understand that furnishings and equipment are characterized much differently than improvements. They aren't all the same thing. And plumbing work, electrical work, that tends to be improvements. Furnishings are the shades, equipment is the dishwasher. That's the way I understand how those terms of art are used in this setting from my off-the-record experience. Is that your understanding?
Your Honor, no, Your Honor. I
Okay,
believe...
tell me why that isn't correct. That's what I need to understand.
Okay. We believe the state legislature has indicated there's no distinction between equipment and improvements. In the HSTPA, I believe it's the Administrative Code 26-516, I believe is the site. But putting aside the actual site, the legislature says they refer to the useful life of improvements. Landlord has to maintain record useful life of improvements. They didn't say equipment, they didn't say furnishings, they said improvements. At least as far as the legislature is concerned, there's no difference. Equipment is subsumed under improvements. And the same is true of the DHCR. When the actual useful life rule was actually promulgated or enacted by the legislature in '93, I believe, and there's the two-page memorandum from DHCR to the governor at the time, which is included in our brief. DHCR doesn't refer to useful life of equipment, they say useful life of improvements. And I think if you actually look at their argument, my opponent's argument, I think the distinction breaks down, becomes unworkable. They say in their brief that the plumbing invoice for $13,000 is all improvements and not equipment. And they say it's $13,000 charge for labor. They're actually wrong. It's $10,000 for labor, $4,000 for materials. If you talk about plumbing, materials would include, obviously, it's pipes, it's piping, pipes, faucets. That's equipment. I don't know. That's equipment.
So
and
let me-
obviously,
let
the
me
labor attached to that would fall in the category. I mean, the labor.
Let me get you back to
I'm sorry?
Judge Stein's question on the useful life schedule for MCIs and its application, if at all, to the IAIs. So is it your position that the useful lives in that schedule are applicable to IAIs as a mandatory matter, or per the DHCR guidance, when you're dealing with IAIs, it's a more flexible issue? And in answering that question, I just wanted to point out, which I'm sure you know, refrigerators, for example, which people might think of as equipment or appliances, are on the MCI schedule with a useful life.
Your Honor, it's a good, interesting question. I guess if you look at the statute, I guess technically the schedule for the MCI improvements, useful life schedule rather, is technically not incorporated within the useful life rule, which is in the provision rather above. It's certainly something the courts can look at, and if you look at the way the courts have applied the useful life rule in the past, they just go to the MCI schedule and apply it towards the IAI rule. But even apart from the MCI schedule, there's no question under IAI, it's in the stabilization code and the stabilization law, landlord has to prove that today's improvement is not within the useful life of yesterday's improvement. There's no question about that. The only question is, either
Yes,
you
but
go...
to put a point on my question,
I'm sorry?
to put a point on my question, suppose the useful life in the MCI schedule is 15 years. Could a landlord for an IAI come in to either DHCR or a court and say, I have conclusive proof that the refrigerator in this apartment was non-functioning and the repairs would have cost more than getting a new, so even though it's not 15 years old, I'm still entitled to an II. Could they do that?
Certainly, Your Honor, but certainly that just goes to the question of who has the burden of proof. They didn't do it, they didn't even try to do it. Today, in their brief, they say everything, they say that today, it was washed away, it was an emergency situation. There's no proof of that. Oh, also in terms of the plumbing, let's say even the plumbing invoice, the pipes are within the wall. They wouldn't have been washed away by any so-called flood, but bottom line from our point of view is they never introduced a single witness to say this is the case. If they had said, the prior, if they'd said, I think was refrigerator that Your Honor was referring to, if they'd said that, I would be in a different position. They'd be in a different position.
Does it make any difference that there were some, to me, the purpose of all of this is so that the landlord doesn't go in and make unnecessary, extravagant improvements so that the rent can it can become a luxury apartment or whatever, right? And here, we did have some photographs, and they, as you know, from what I can tell, they don't show that this was some luxury improvement here. It looks pretty basic. So can that kind of proof corroborate support an inference that they wouldn't have spent this kind of money if they didn't need to?
You know, our position is no, because, first of all, the photographs don't show you what the condition of the apartment was before they made the improvements in '09. It doesn't tell you the pre-improvement condition of the apartment. And moreover, there are multiple inferences that can be drawn from the fact that they spent supposedly a lot of money. Maybe they want to spend more money to make the apartment marketable. That's possible. Maybe they spent more money, and I'm just suggesting, maybe there are some kickbacks going on. That's an inference you can draw. I'm not saying there were kickbacks, but there's certainly, that's an inference. So I would answer basically no. I don't believe you can tell from the photographs what certainly can't tell from the photographs what the prior improvements were and what the condition of the apartment was before the IAI.
Thank you, counsel. Counsel?
Yes, thank you.
May it please the court, my name is Richard Feldman. I'm appearing for the respondents. Prior to this court's decision in Regina in April of 2020, there was a confusion that existed in terms of the applicability of the 4-year look-back rule and what a rent history was comprised of. This court made it clear under Regina that the absent fraud, which is not present in this case, you can't look back more than 4 years. And an owner, landlord, does not have to retain documents beyond 6 years. Here, the lower court made errors of law when I asked to preclude the consideration of the useful life argument for improvements that were done in 1995 and 1998. And again, the action was commenced in 2011, obviously more than 4 years.
But so counsel, the argument you're making then is effectively a landlord can replace anything in an apartment as long as 4 years has gone by, and that's then unquestionable.
The tenant in occupancy
Yeah.
would be the real party in interest, because their rent would have been increased 1/40th of the improvement.
But here there was a vacancy.
Correct. And work was done, and apparently there's no argument that $78,000 in qualified IAI improvements was performed. And the argument now is that work done in 1995 and 1998, as reflected on the rent history, should somehow reduce or eliminate the consideration of those.
I'm over here. Sorry.
Yes, I'm
Can you
sorry.
see me there? Okay, that's fair. No, I thought the argument was that the landlord bears the burden of establishing that whatever improvements you make, you can go make them. It's whether or not you can then seek to take this rent out of rent stabilization. That's the whole point. So I thought the argument was to be able to do that, you have to show that the useful life of the prior improvement has expired.
Except for one of...
Do you not understand the law that way? Do you see it a different way?
I see it a different way, Your Honor.
Okay, what is that?
Given the document retention policy under the statute, where landlords only have to retain documents for 6 years.
No, that was not my question.
No, but
No, please.
Sure.
That was not my question. My question is, did you see that requirement under the law? Put aside for the moment how you might establish that. What proof you would have to bring forward to establish that. I'm asking you if you see the law functioning in that way, that those are the requirements that the landlord is subject to.
I believe if it's raised in the pleadings, so it's not a surprise by ambush, so the landlord has an adequate opportunity to research and try to obtain records that are decades old.
Well, wait a second here. First of all, the plaintiff sued for a rent overcharge, right?
Correct.
And you answered. And was there anything in your answer that specified that the deregulation was based on IAIs?
No, we simply...
So how would it become the burden of the plaintiff to plead or establish something, first of all, pre any discovery at all, that they don't even know what it's based on?
So once they start a lawsuit alleging a rent overcharge, And in the complaint, they clearly refer to rent registrations, so they're aware of the increases in rent historically, so they can allege whatever they want. Their records are as available to them as to anyone else, the DHCR records.
So they did put you on notice in the final pretrial,
A
right?
month before the trial,
So, right.
after all
Just-
discovery is complete.
I just want to know if that's true.
Yeah, that's correct.
Okay, so what, if anything, did you do when you saw that? Did you ask to move the trial date, ask for more time to find things, ask to move and eliminate to prevent them from making anything?
The records from the plumber.
You know, I'm asking
No,
if
no,
you
we didn't
did,
do
if
it.
you, the
We did
lawyer,
not.
did anything.
We did not, Your Honor.
Okay.
We did not.
And did you speak to, at the trial court, anything that you would have or could have done differently in terms of presenting proof had you known earlier? Did you present any arguments to specify what prejudice you suffered as a result of this to the trial court?
I did, Your Honor. On A96 and 97, I objected and sought to preclude the rent history, and that's A145 and 146.
Yeah, and did you talk about how it would prevent you from presenting?
I believe I mentioned the fact that these improvements were so old, 95 and 98. It made it virtually impossible to find witnesses or to get records.
Let me ask you a little differently. You did have some witnesses and some proof regarding these repairs or improvements.
No, we had no witnesses as to the 1995 and 1998 improvements.
Well,
In terms of contractors.
Nobody with personal knowledge, right?
Correct.
You had people that worked for you and could give some general information. Okay.
But again, it's an over 400-unit building, rent stabilized, filing DHCR reports since 1984.
So, counsel, let me ask you, I'm over here again.
Yes.
Counsel, let me ask you. So if the schedule says the useful life of a particular improvement is 30 years, what's your understanding of whether or not the landlord then bears a burden to keep documentation for 30 years? Is that the way you see it, or do you see that means nothing? What's the point of it?
I don't know the answer to that, Your Honor. I could see arguments on both sides of that question. There is the 6-year statutory requirement to maintain records. That's clear in the statute. There may be a practical problem in terms of, here you had a sale of the building, so you have that issue that goes along with that and a change of agents. You know, on a certain level, it renders residential properties unmarketable to impose such lengthy record-keeping requirements, especially for records that go back prior to the advent of the computer.
But your
That are on paper only.
But doesn't your argument also entirely wipe out the MCI requirements?
It doesn't, Your Honor.
Well, some of those.
This is not an
This
MCI
is not an
case.
MCI, this is an IAI.
I understand that, but
Yes.
your argument is that, you're not saying that landlords have a 6-year record retention for IAIs, but 30 years for MCIs.
Just like the Appellate Division First Department held in Fuentes. They said, you know what, if you don't give the tenant the notice when an apartment is deregulated, the remedy is you must give that tenant a rent-stabilized lease. But you can't go back and hit the landlord with rent overcharges, because the document retention policy is statutory, it's limited, 6 years. So in this case,
But then what is, let's try it a different way. What is a tenant to do, since the records would originally be in the landlord's hands? I mean, the tenant, and there might be future tenants, the tenant wasn't there when you made the improvement, et cetera, et cetera. What is that tenant to do if you're not going to have these records? And because I thought you said the burden's on them, go find records.
well,
If you can't find them because you didn't keep them, how is the tenant going to do that? Or did I misunderstand your argument?
You did not misunderstand it at all, Your Honor. And the problem is, given the passage of time, and here it's decades involving the Windermere, from 1984 onward, and the improvements were done in 95 and 98, and the trials in 2016, what is a landlord
Yeah,
to
but
do?
the law is clear that you cannot, if it's a duplication, and the useful life is not expired, again, you can make any improvements you want. No one's saying you can't in that sense, but you can't then use it to try and increase the rent, or take it out of rent stabilization. That's the point. It's not about whether or not you can or can't, and how you would retain your records, or what kind of proof you choose to put forward to carry your burden.
I agree, Your Honor. However, in this case, in this particular case before Your Honors,
Yeah.
the internal cohesion between the various trades in terms of the work performed and the scheduling of the work corroborates the fact that it was a gut renovation and that the entire apartment was done. So if you look at the scheduling of the plumber, which is on 653.
So just to be clear, so this part of your argument is that if there is some burden to carry, you satisfied it because you put forward, if it's not the kind of documents the tenant might argue for, you've put forward the kind of testimony and other documentation that carried your burden. Right?
Correct. That shows it's a gut
Fair enough.
renovation, that it was complete, and that to the extent it was caused by water damage, the statute allows under MCI to start a new, to wipe out the old useful life schedules, because the policy is to put these housing accommodations back on the market, not keep them off the market till a stale useful life runs its course. That makes no sense to anyone.
Thank you, counsel. Counsel?
Yes, Your Honor. With regard to the question of proof with regard to the prior improvements and the question of prejudice, apart from the fact they never made a claim of prejudice, and I'll let the record speak for itself. I mean, they never made it, even once we were in the appellate division, they didn't even claim to the appellate division there was prejudice, though the appellate division did find prejudice, at least. But with regard to, with regard to the, they did have within their possession evidence which could have answered this question. What were the prior improvements? The evidence showed that, the law shows that when they made the prior improvements in 95, 98, and took an increase, they're supposed to file a registration statement with the HCR, which says, this is what we spent, this is what we improved. And you have in the record blank registration statements, which they were supposed to fill out.
Where do you see that requirement in the statute or the regs? I mean, I understand the form has space to do that, but where is that requirement to be itemized?
Well, it's on the form. The form is the DHCR form. So the DHCR, by promulgating that form, with the blank is in the record, they're asking them, meaning the landlord, what did you spend? What did you spend it on? The point is, when we filed suit in 2011, the evidence was they had those forms in their possession in that year, 2011, which would have told us what they spent, and they never produced those.
They could have filled the forms out, but they could have also kept receipts and not filled the forms out and still be able to satisfy their burden of proof.
Well, they could have.
Right?
Yes, Your Honor.
Yeah, so it's not a requirement that they fill the forms out.
Well,
it would have been convenient for them. In hindsight, they probably should have, but
well,
I mean, can you point me to a legal requirement that they itemize on those forms?
Other than the form itself, which is a DHCR form?
Right.
I would just point you to the DHCR form, which requires, the administrative agency, DHCR, requires them, and certainly they have the authority to do that, to itemize the improvements. They didn't produce those forms. And, to Your Honor, could they have produced invoices? Of course they could have, but they did. And they certainly, their property manager at the time of 95, 98 was a witness for them at the trial in this case. And he said, I don't know about the prior improvements. So I don't see...
But if a witness testifies, I can't remember the whole itemization, here's the total number, but all of that was done in that apartment. All of that was done in that apartment. These are the general types of repairs. I can't tell you now to the cent what was done in this room or on this, but all of these repairs, this is the total amount we charged, that's the total amount paid, and it was in that apartment. Is that enough?
Certainly, Your Honor. Certainly, Mr. Balkman, who was the property manager there with us, he could have testified in general terms as to what he did, would have done, most likely did. He didn't even try to do that. He didn't even try. It's their witness, not mine.
So is your position then that their burden is they've got to bring in every tradesperson who did every bit of work to testify about what they did in the apartment?
Some evidence. The DHCR form, which they had in their possession when we brought suit, they didn't bring in Mr. Balkman. Maybe somebody else. Maybe a document. Certainly Mr. Balkman, who was at trial. They could have had him testify in general terms.
Thank you, counsel.
Thank you, Your Honor.
hear ye, hear ye. All persons having any further business before this Court of Appeals held in and for the state of New York may depart hence and appear here this afternoon at 2 o'clock, which time this court now stands adjourned. Judges of the court, all please rise. Hear ye, hear ye, hear ye. All persons having any business before this Court of Appeals held in and for the state of New York, may now draw near. Give their attendance, and they will be heard. Please be seated.
Okay, good afternoon, everyone. The first appeal on this afternoon's calendar is Appeal Number 79, the people of the state of New York versus Everett Balkman. Counsel?
Thank you. My name is Janet Soames. I represent Mr. Balkman, and I'd like to reserve 2 minutes for rebuttal.
You may. Counsel, I have a question before you start. Are you arguing that the police can't stop a driver based on a DMV similarity hit, or are you arguing that there was a failure of proof on the part of the people?
There's a failure of proof on the part of the people here.
Thank you.
Sustaining the stop in this case, under the facts of this case, cede a determination of reasonable suspicion to a computer program about which we know nothing, except that somehow it uses a name, date of birth, and aliases to issue some sort of notice about the similarity between the registered owner of a car and a warranted person.
So
It also
I'm sorry, I'm over here. I know it's difficult. Just to clarify on this point that you're making right now, is it that you're saying that the prosecutor had to put in proof about how this system works, or just what was visible to the officer?
I think that the prosecution could have done either, but they did neither. And therefore, we don't have objective facts on the record from which...
Well, if it's just how it works, it doesn't tell you what the officer actually saw.
We need what the officer saw.
Right.
I assume that if the officer...
So do you really need to know how the whole system works, if all you really want to know is what did this officer see at the time they made the choice to stop the car?
I think that what the officer saw is one way. I think that if there was proof about how the system worked, then possibly if the officer here had said that he assumed there was a warrant based on the similarity hit, or that he believed there was a warrant, then there might be some proof in the record to support his belief, but we don't have that here.
Do you need something about the accuracy, the rate of false positives, something like that?
Certainly that would be one way that they could also establish the reasonableness of the officer's belief, if he had such a belief, because here he didn't say he believed it. But we have no idea what the accuracy rate is. We don't know if it's 1 in 1,000 returns an actual warrant. Is it 1 in 500? We have no idea on the basis of this record whether or not there is any likelihood, or what the likelihood might be, that the warrant is actually for the registered owner of the car. So this record, we don't know the name of the person with the warrant. We don't know the name of the registered owner. We don't know what the supposed similarity was. We don't know what he saw on the screen. But what we do know is that he had literally at his fingertips the means to find out whether or not there was a warrant for the registered owner of the car. But he didn't look at that information. Now, the people they argue that it's not safe for him to do so while driving. He didn't have to do so while driving. He could have radioed to someone and asked for help in ascertaining whether there was a warrant. He could have followed the car for a while.
Wouldn't that also go, I mean, I think to Judge Rivera's point, it really would depend on, let's say they did come in and say, look, there was a warrant out, same name, bank robber, 5 minutes ago. Would you really have to go check, or in that situation, could you just pull the person over? I mean, wouldn't it really depend on what's on the screen?
I think it does depend on what's on the screen, yes.
And I mean, I take your point that there's pretty much, we don't know anything about what was on the screen here, except maybe I think that the warrant was out of Rochester, right?
There was a warrant was out of Rochester, yes. That's about all we know.
What if the police officer stopped them, then went and looked, read what was on the screen, saw that it didn't seem to be a match? Wouldn't that officer either have a responsibility to, or at least be able to, walk over to the car and explain why they were stopped, and maybe apologize, or whatever? And then doesn't the plain view doctrine jump in here And so I guess my question with that is that is your argument here, does that put limitations on the availability of the plain view doctrine?
I don't believe so. First of all, I think that if he pulled over the car and then he checks and finds out there isn't a warrant, he has no obligation to go up the car. That almost turns into, an unreasonable stop at that point.
Well, let me ask you
He already
something
knows.
different. What if the police officer saw something, a problem with the car that maybe the owner wasn't, the driver wasn't aware of and wanted to make a safety stop? Then the stop is okay, right? So are you suggesting that you can't do that?
I'm suggesting that once he realized that there's no warrant, he has no reason to continue to seize that car, and he can very easily drive by, wave, get on his loudspeaker, say, hey, have a good day, whatever it is. But once he knows...
So at that point, it would be improper for him to even walk over to the car to...
I believe it would be improper for him, because that is a seizure that is then continuing, and he has no basis to continue that seizure. What the officer did here, though, was takes almost into Ingle territory, where he kind of nosed around the car. He was checking the registration, checking the inspection to make sure it was all legit, and there was no basis to do that.
So I know you're taking the position, as you've already responded to the Chief Judge's question, that there was a failure of proof here. But is there, from your perspective, a minimum? Is there a floor, at least? Or it's always a case-by-case determination? Is there something that, from your position, you would argue, look, that's the minimum, you got to have that. If you have more, that's a different story.
I think that at a minimum, when it comes to the reasonable suspicion issue, at a minimum, there has to be evidence in the record from which a reviewing court can take a look and make a determination as to whether or not the officer reasonably believed what he claimed to have believed, which again, he didn't even say that he believed there was a warrant here. So yes, I think that there is a minimum, and again, we don't have it here.
Thank you, counsel. Counsel?
May it please the court, Lisa Gray for the people. Good afternoon, your honors. In this case, the police officer presented specific and articulable facts at the hearing to establish that there was a similarity hit for the registered owner of the vehicle.
So what are the specific facts that you believe the evidence showed?
Well, he had information that the warrant was a localized warrant out of the city of Rochester. He had the make and model of the vehicle. He knew that the registered owner was a male, and that vehicle associated with the warrant was being operated in the jurisdiction out of which the warrant was issued.
But was the vehicle, was the vehicle associated with the warrant? I thought it was a similarity on the name.
The police officer ran the plate through his MDT and revealed the registered owner of the vehicle as being similar to somebody with a warrant out of the city of Rochester.
Right, but there's no connection
How does the reviewing court test that when you don't even know what the names are? One of the reasons I use my middle initial is because there's a lawyer who practiced in the same jurisdiction that I practiced with exactly the same name. The only difference is our middle name. We don't know any of that information here.
Well, the police officer did explain during the hearing that oftentimes these similarity hits do come from far-flung jurisdictions, Texas, California. In this particular case, not only was it narrowed down to the county of Monroe, it was narrowed down to the city of Rochester. And as he explained to the court, that gave him heightened attention to do his duty, which was to investigate that potential warrant of the operator of that vehicle or one of the occupants of that car.
Well, you gave, for example, the fact that it was out of the city of Rochester and the registered owner was a male. That's pretty broad. So how do we know that the requirements for having a similarity hit, DMV's requirements, aren't unreasonably broad so that it would capture, many people that it didn't apply to? How would we know that, and don't we need to know that?
Well, I think we do know that from the hearing, and that is that the DMV, the triggering mechanisms that the officer testified to include name, date of birth, aliases from perhaps previous arrests.
But we don't know how similar the names are. I mean, maybe the names had the same first letter of the first name and the last name, and that was it, and the names were completely different.
And in this case, the police officer was reasonable in pulling over that car in order to investigate that equivocal fact situation.
But how do we know that, I guess, is the point Judge Stein's trying to make. We don't know what the similarity was. We don't know if it was off by a letter, if it was a full name with an initial, if it was an age and date of birth match. We don't know any of that.
But we do know that it was a localized warrant out of the city of Rochester that had a potential similarity to the registered owner of the vehicle. And it was reasonable for that police officer to pull the car over in order to...
So why couldn't he, when he pulls the car over, though, do exactly what I think was discussed by one of my colleagues earlier, which is, okay, you pulled the car over, the car is pulled over, there's no indication the car is fleeing. Now read it and take a look at it, because he didn't want to do it while he was driving.
Because at that point, the seizures already happened. The seizures already happened. So whether or not the police officer sits in his car and
Yes, but it
reads
would
through information and
dissipate either
synthesizes it,
or raise, perhaps the quantum of information, wouldn't it?
that would be no less of an intrusion on the operator, the occupants of that car, because
But
at that point...
it's more intrusive to actually go over, right? I mean, yes, of course, you've got to stop because you've stopped the car. No one's disagreeing with you, but isn't it even a heightened level of intrusion to actually get up, walk over to the car?
Respectfully, I would disagree, because in this case, the police officer told the court that it was between 20 and 30 seconds by the time he observed that loaded gun between the appellant's feet, whereas if...
No, but that's already going to the car. I think the point was, once you make the stop, why not then look at the screen or do whatever other search you can to get a better sense of whether or not there is a basis for this stop.
He would be prolonging that detention of the occupants by looking through 25 pages of MDT material, synthesizing it, assimilating it. I think he said it took maybe about 20 seconds per page. So he would have been sitting there for about 5 minutes trying to figure out...
But we can't even evaluate that claim because that's not in the record, right? I mean, you could have printed the thing out and put it... Do you know why it's not in the record?
He testified at the hearing that I believe there were about 20 or 25 pages of information that he would have had to read and synthesize and assimilate and then make a determination, all while driving and keeping the suspect car in view. And he told the hearing court that even doing that would have been difficult. This was a limited intrusion, a 20 to 30 second interaction with the driver. And he tells the driver, listen, the registered owner of the car may have a warrant, and she informs him that it's her brother who's the registered owner. He also knows that there's an adult male in that car.
Is he more likely to get untainted information by looking at those pages?
I mean, not necessarily.
As opposed to what someone may or may not tell him?
Not necessarily. We certainly know that there are cases out there where police officers have relied on MDT information that turns out to be stale or, resolved information that the DMV just hasn't updated in their computers, but that isn't the case here. So it was in his discretion to do a limited intrusion of a quick car stop, much like a show-up procedure.
The similarity could be stale too, right?
I'm sorry, Your Honor?
The similarity, it could be stale too?
In this case, it wasn't. He was able to determine that the registered owner did not have
But
a
it
warrant.
could be. It's sort of
the warrant was-
following your analysis of a case. It could be.
Yes, but in this case, that's not in this case. I mean, there was a warrant, it just wasn't for the registered owner of the vehicle.
Let me ask you this, if you do that, just that similarity hit, maybe all you realize at once is that the owner is male, okay?
Yes.
You stop the car, you start walking, you see that the driver's female alone. I know in this case there were two other men. What should the officer do?
Well, again, I think that goes back to my previous point, that at that point, the limited seizure has happened. He's allowed to address the driver. He has that short conversation with her. Those are reasonable steps to investigate this particular warrant and where that wanted suspect is, whether or not it's the
But
operator
learning what?
or the
I mean, doesn't
occupant.
the officer still have to confirm that indeed the warrant is for the owner of that car?
Yes, he does, and he did that in this case.
But what I'm
And in
saying is,
fact, it
how's he
wasn't.
going to get that from her? So what's the point of asking her in my hypothetical?
Because he had a duty to investigate that warrant. So she's the operator of that vehicle. He immediately tells her, listen, you're not the subject of the warrant. I know it's a man. And she volunteers information about the registered owner. So he is in furtherance of his duty to do that investigation.
And if she doesn't want to talk to him, what happens next? She says, I don't have to talk to you.
Then I think that at that point, he could perhaps ask for identification of the other people in the vehicle.
No, in my hypothetical, where she's alone, and obviously is not the owner, because the owner is identified as male.
I think under that hypothetical, if she's alone in the vehicle and he knows that the registered owner is a male, then then at that point, probably he could say, have a nice night and be on your way, female operator. But that's not what happened in this case.
No, I understand.
So what would happen if in that very, very brief period of time, he looked down on the floor and saw a firearm?
I'm sorry, Your Honor. What?
So what would happen if in that very brief period of time in which he...
Again, I think the analysis is still the same. It's that at that point, he would be lawfully present in order to make that observation. He does see that the operator is female versus, let's say, a registered owner who's a male. But he's lawfully there, but he doesn't even get, in your scenario, he doesn't even get a chance to wave her on because now he has seen evidence of contraband in plain view. He's lawfully present under the other scenario, and he would wave her on, but now he sees contraband, and he would be lawfully present. He's still lawfully present at that driver's side window.
Can I ask you, a lot of times in these cases, even though they're so fact-intensive, there's a snowflake-like quality to them, usually a series of factors that a court can look to evaluate them. What factors would you have us to look at in this similarity hit problem to establish that there was reasonable suspicion?
I think the factors that this court should look at are the...
Let's say in every similarity hit type, these kind of problems of identification through highly technical computer programs are going to become more prevalent rather than less prevalent. That's why I'm asking you, because this case really could carry over and have more effect beyond simply this particular stop.
I think generally the factors of what makes up the similarity hit, which was certainly explained by the officer in this case, in terms of the triggering mechanisms, the different criteria that would bring the information forth through the MDT, and the factors of the similarity hit in terms of whatever the particular similarity hit is based on.
You see the problem if you let's say you move into another type of technology like facial recognition technology, and the problem of similarity hits. You see how a lack of clearly defined factors that are set out in clear proof standards could really wreak havoc on all of our rights?
I believe the standard still remains, what is that quantum of knowledge that the police officer had in order to establish reasonable suspicion? And reasonable suspicion has never required the police officer to establish with absolute certainty that criminality...
I think you're totally right, and that'd be unfair, and that would be a bad idea. We wouldn't be able to protect society in any way.
So
I agree with you. Yeah.
So police officers are at times presented with equivocal fact scenarios. So they do have a duty to investigate that. And the similarity hit is no different than facial recognition technology that may be used in law enforcement in the future. And in this case, the police officer had that quantum of knowledge. The people presented enough evidence at the hearing to establish that.
One of the things I struggled with is I had nothing to compare it to. You said it was similar, but it didn't seem like the record really established the similarity. The name, the warrant, the look of the person, none of that was in the record. It was difficult.
Well, again, I think we know that it was a localized warrant coming out of the city of Rochester. The police officer testified generally as to what those triggering mechanisms were. We had the registered owner as a male, and the car associated with the person who could have the warrant was being operated in the jurisdiction out of which the warrant was issued. So all of those things, the trial court correctly concluded, the appellate division affirmed that gave rise to reasonable suspicion. Similarity hit based on a judicially authored warrant can give rise to reasonable suspicion and sustain a traffic stop in New York.
Thank you, counsel. Counsel?
Going to Judge Fahey's question, I think that your illustration of facial recognition is a good one here, because in order to be able to determine whether or not any hit was reasonable, you would need the two screens, the two screens of the face, so that you can make a comparison. And here, if they brought in the screens that the officer actually looked at, there would be a basis for comparison, but they didn't, and so there is not. The decision, below incentivizes the police not to look at readily available information, which will tell them whether or not there's a warrant for the registered owner of the car. And going to Judge Feinman's concern about why he uses a middle initial, if a person is swept up in these similarity hits and they're not the person that has the warrant, then that person is going to be subject to being stopped over and over and over again. And he or she will have no means to clear it up, because only the person with the warrant could clear it up and get it out of the database.
Thank you, counsel. The next appeal on this afternoon's calendar is appeal number 49, the matter of Marion T. Let's just wait a moment until counsel clears out. Okay. Good afternoon, counsel.
Good afternoon. I'm Callan Connors-Brennan. I would like to reserve 2 minutes for rebuttal, if I may.
Of course.
This case involves the adoption of an adult woman who is not capable of providing consent to the adoption. We take the position...
Wait, how do we know that?
The respondent has...
Couldn't make a finding about that, right?
Your Honor, with respect, I believe that, all of the lower courts, both the trial court, the surrogates court, and the appellate division did conclude that Marion does not have consent, does not have the capacity to give consent for this. I honestly don't think that that's an issue on this record, and I think that, looking at the facts of this case, whether or not she has that capacity is not one of the problems before the court.
Well, this surrogate did an investigation, if you will, into that question.
There was some investigation done into that question.
There were experts that gave reports and
That's correct. There were 2 psychologists who did examinations and provided reports. The court also did do its own, had a meeting with, the surrogates court did have a meeting with respondent to assess for himself whether or not he believed she had the capacity to provide the consent. The guardian ad litem also offered an opinion that she didn't have capacity to provide consent. And she has been, for her whole life, diagnosed with profound intellectual disability.
Did I misunderstand the record? I thought Fox had said she had consented. Am I wrong about that?
Dr. Fox attempted to distinguish between her lack of capacity in all other areas and her ability to consent to an adoption. He attempted to say that although she lacks the capacity to consent to routine medical procedures, she does have the capacity to say yes if somebody asks her whether or not she wants to be adopted. I don't believe that his opinion was really worthwhile, and it wasn't explored during the hearing. Neither of the experts testified at the hearing, and there was no direct or cross-examination of their opinions. I think the court essentially moved on after receiving those reports, and everybody agreed that, the consent issue was, her capacity to provide consent was agreed upon. She did not have that capacity. What the surrogate court then did was subsume her capacity, her consent into the best interest analysis, and then also seemingly accepted a consent on her behalf that the guardian ad litem actually never provided. So that way it was the issue of...
Can I ask you a question about that? Because I know that's one of the main points of contention here is when the ability to consent is explored, or in what context. So it's a process, right? So if you say that ability to consent has to be determined first, okay? And again, this is assuming that the court can dispense with that consent. Then you have to go through this whole process, right? Whatever that may be, to determine her ability to consent, and then and then let's say the court finds that she doesn't have the ability to consent, and then moves on to the best interest. What difference does it make if it's all done at once, as long as the ability to consent is a required finding in the process? Why does it make such a difference whether we call it a threshold determination or whether it's just part of the overall determination?
Well, Your Honor, part of the problem would be that notice of the proceeding is only required by the statute to be given to those whose consent is required. So if the consent of an adult...
How could you determine if her consent was required unless you determined whether she was capable of giving consent? So wouldn't that presume some notice and some involvement of her and people around her who know?
So petitioners could submit an application a petition to the court for adoption, support it with the opinion of an expert and some documentation that the individual to be adopted lacks the capacity to provide consent, and ask the court to dispense with the consent and proceed without any notice or any further examination of the issue. They have, the court would have in front of it an expert opinion and other documentation supporting the fact that there's, this person lacks consent, lacks the ability to provide consent, and so we don't need to visit that issue. Let's move on to the best interest.
Well, so in this particular situation, she was in the custody of the state of New York, correct?
That's correct.
So does the state have to be given any notice?
Not under the adoption statute.
Well,
it doesn't.
How did she end up getting a lawyer?
I believe that she ended up getting a lawyer because the surrogate had never been faced with such a situation, had no idea how to proceed with such a situation, and had a good relationship with the mental hygiene legal service attorney who covered that area, and decided that he needed to bring her in and have her.
So would it arguably be an abuse of discretion not to somehow get the alleged incapacitated person to be heard in some fashion?
I think what is an abuse of discretion is dispensing with the consent of an adult. I think that's the ultimate abuse of discretion in this case.
Counsel, if she could not consent, and we can't dispense with consent, then anyone in this situation over the age of 18 could not be adopted.
If there's not an ability to provide consent,
Right.
and there's no way to, support their decision-making and educate them and get them to be able to consent, then no, they can't.
No matter what procedure, no matter the best interest of the child, there's just a bar. So if you start a petition before and the person's 17, but you don't get a ruling, they turn 18, you're done. It's over. You can't consent, you're 18, we dismiss. You can never get adopted.
Not under the current statute. This court would be creating a whole new statutory scheme to allow something
Actually,
like
we'd
that
be
to happen.
reading the statute in a way that you don't agree with, but I don't think we would be creating
How can
a
such a
scheme.
person consent to be in the care and custody of the state?
She actually was placed into the care and custody of the state by her biological parents when she was still a child.
So, but she never had the right to, when she became 18, to make a different choice, right?
She could have, she never did.
Well, how could she have if she doesn't have the capacity, the mental capacity to make that determination?
Well, it is a voluntary program, and people can sign themselves out. If she attempted to sign herself out and somebody believed that that was dangerous and that she lacked capacity to be able to do that, then again, the legislature has created a large statutory scheme in order to deal with this through guardianships. And practically anybody can bring a guardianship proceeding to try and protect the interests of a vulnerable adult, either under Surrogates Court Procedure Act 17A or under
So your red
Mental
light is
Hygiene
on.
Law
To be
81.
clear, very quickly, what is your position on what should have happened here? Since you're starting from the point that she couldn't consent, what should have happened?
The petition should have been dismissed. It couldn't go forward. She couldn't provide consent. It can't go forward.
Thank you, counsel. Counsel?
Yes, that's the worst of it. A whole class of people are excluded, people who are the most vulnerable, least protected, unable to articulate their own desires, not even ask. Marion wasn't asked if she wanted an attorney. Marion wasn't asked if she wanted to appeal her case to the appellate division. Marion didn't send me here. Marion hasn't. Marion believes that she should have the ability to be autonomous and make decisions, but Marion cannot articulate in a conventional fashion a consent, a legally cognizable consent, because she can't talk that way.
Can she communicate that in some other way? Are you saying she
Yes,
actually
she-
could consent, but just not verbally?
Absolutely, that's exactly right.
Okay. So then,
Which is what-
let me just, please, to clarify, is it your position that there was not a finding that she couldn't consent? Sorry for the double negative.
I draw a distinction, Judge,
Okay.
between the consent that she can give and the consent that the court was looking for. The court was looking for an understanding of the adoption process and what that meant. And Marion doesn't understand that, I don't believe. But Marion does very clearly understand the family that she's a part of, that she's been adopted into, what they mean to her, that she was very insecure when she was removed from that family by the state, who was in control of her life then.
Okay, so then is your position, and I think it's along the lines of what Judge Garcia was asking about before, that if an adult individual cannot give consent, right, given the nature of their disability, is not able, as you're saying with this description, able to appreciate what adoption means, therefore cannot really give a legal consent, that a judge or the surrogate should dispense with the consent requirement and move forward with the petition?
I think that's what the courts have concluded. They did take a convoluted route to get there. I'm not sure that that's required. But ultimately, if they determine that someone cannot consent, they can look all around at the other components of the decision-making process, the best interest of the child.
And but if a judge chooses not to do that, would it be an abuse of discretion?
If the judge chooses to find no consent.
If the judge concludes,
says-
this person cannot consent, but I'm not going to dispense with the consent requirement, I'm going to dismiss the petition, would that be an abuse of discretion?
I think without more, I think he has to examine
she,
the situation to determine what the best interests of the child are. Otherwise, you would have this automatic preclusion of the entire class of vulnerable
So you're saying
people.
under this particular factual scenario, a judge cannot conclude that they do not want to exercise their discretion in a way to dispense with consent?
I think the judge can exercise his discretion.
His or her.
To not dispense, his or her, to dispense with the consent requirement based on facts that he has to support such a decision. He can look behind the petition. He, as they did here, call witnesses, examine Marion, talk to the guardian ad litem. All of that was done here, and I think that is appropriate in determining the best.
Let me ask you a question, if I could. If Marion hadn't been removed from the home and there had been, I guess it was the Justice Center that did an investigation, is that right?
The state,
It was an agency of the state, I don't know which one it was. I thought it was the Justice Center.
what they call, the local entity of.
Okay. If that hadn't taken place, would we be here today with this adoption petition?
Yes, yeah.
Well, how
I
so?
hope we wouldn't be here. But we would have been in
Fair
the
enough.
adoption.
How would this have gone forward in the absence of
The
that?
adoption petition preceded the removal by the state component.
I see. Now, taking it to the next level, it's clear, even in the record that we do have, that there is a loving bond between Marion and the petitioners here.
Absolutely.
I think that's clear, and the court understands that. I guess my question to you is, consent to adoption isn't the same for an adult as a loving bond. You can certainly have a loving bond and have it strongly, but not necessarily say or agree that you want to be adopted, how are we to reconcile those two things?
I think that's where the exercise of discretion comes in and why the statute plainly says the judge
So
can do
are
that.
we saying that perhaps something similar to Bennett v. Jeffries, kind of an extraordinary circumstances evaluation that needs to take place, and then you look at the best interests of the person?
Yes, it is an unusual circumstance. I'm not sure it amounts to extraordinary, but yes.
And
look underneath the petition and see it. There was a case out of Chemung County last year where the petition was found to be based on a malicious motive, and that was not, the adoption wasn't allowed to go forward. This is entirely different. There's no evidence that there is any untoward aspect of this family, and Marion has been part of it for more than a decade.
All right, I want to change tracks for a moment over here. And it's a statutory interpretation question. So why isn't an interpretation of 111 sub 1 sub a that limits the definition of adoptive child to minor children between 14 to 17, why isn't that the most consistent interpretation with the legislative history that underlies that provision?
I can't explain the operations of the legislature. I don't know.
Okay, fair enough.
Thank you, counsel. Counsel?
Yes, so two things, if I may. I want to address the concerns, the stated concerns that an entire class of people will lose out on the ability to be adopted. And I want to point out that, the risk of adopting out people who are not able to object to that adoption is so much greater. Those people will have all of their family ties, all of their biological family ties cut, and a whole new family structure put in place.
But isn't that true of anyone subject to an adoption? And isn't that why there's a best interest determination to be made in every adoption case, whether it's a child, whether it's an adult?
But, Your Honor, there's also consents required in every other adoption case.
But your
Either
rule,
the consents of the parents.
to follow up on Judge Stein's point, your rule, and this is something the court in many contexts has been very hesitant to do, your rule is reading the best interests of the child or adult out of the adoption process, right?
You still get there after you get through the consent. The legislature simply has not put into
you're
place
making
a structure
consent-
to allow something like this to
You're
happen.
making consent a bar to that, reaching that issue. I mean, in your rule, you never get to best interest because you can't get through the consent doorway, right?
Under the particular circumstances here of this vulnerable class of adults who are not able to provide the requisite
And
consent.
why isn't this vulnerable class of adults even more in need of a best interest type analysis than anyone else?
But what they're in need of is protection from being adopted over their objection, or if they
But
may
they
have, they
can
may
object
object,
or
or they may
consent.
not. But we don't know, which is why they need to be protected from their assets being distributed, even during their lifetime, let alone after they've passed on.
And I think that is a legitimate concern, of course, and I thought from this record that that was one of the things that the Surrogates Court went into.
I don't know that there was really very much examination. The examination into the best interest really involved whether or not Marion was going to lose a lot of services that were available to her. She's not going to lose a lot of services. She loses a lot of oversight. She potentially, and her family members potentially, lose the distribution of assets. She also cannot inherit from many of her other family members after being adopted.
She can inherit from her adoptive parents, and again, that's true of any adoption. I mean, there are certainly infants that are adopted possibly from very wealthy families to not as well-off families.
But consents have been given. Consents have been obtained from
The parents.
from the biological parents.
Not by the adoptee.
But we're talking about an adult, not a child, and that's why an adult adoptee provides their own consent.
But neither the child nor the adult in this situation is capable of consent.
But she's still an adult, and her interests are still different, and she's still an individual with all of the rights, privileges, obligations of any other adult, and she needs to be able to make those decisions for herself. And if she can't, nobody should be able to impose a new legal family structure on her, all of the legal trappings that come along with an adoption.
So then what, is she then get a guardian? She's not adopted, she remains in this home and has a separate guardian?
She could get a guardian, she doesn't have to. There are many people who don't have, live in these circumstances that don't have guardians, but she certainly can have a guardian if somebody wanted to apply. And through the guardianship statutes that have been put in place thoughtfully by the legislature, there are all kinds of protections there to make sure that her assets are not dispensed with, that she is, getting all of the services that she's entitled to. There's, reporting to the court to make sure that the guardian is following through their duties. They have fiduciary duties.
If I could just quickly interrupt you, I see the red light is up.
I'm sorry.
So right now, your position is based on statutory interpretation. You're not making some argument that the legislature couldn't change the statute.
That's correct.
To allow for this best interest analysis to apply, as opposed to the result that you described, which is if you can't provide consent, they can't be adopted.
That's correct. If there's a hole, it's a hole for the legislature to fill.
Thank you, counsel.
All please rise. Hear ye, hear ye, hear ye. All persons having any further business before this Court of Appeals held in and for the state of New York, may depart hence and appear here Thursday morning at 11 o'clock, to which time this court now stands adjourned.